Alrighty, this will be the People News. One more time at it. Never look straight forward. Always look around. You'll be able to protect yourself by any means necessary. Alrighty. Arm yourself with knowledge. People use that Second Amendment to the best of your abilities. And these judges are going to keep running people over until we stand up and actually protect our own selves. Everybody keeps on throwing the buck to somebody else. But these courts don't have jurisdiction, so your attorney, most likely, is never going to challenge the jurisdiction of all this. And there has not yet been proven that there was actually a lawful warrant prior or the day of the arrest. Now, there had been a warrant issued a few days later, according to the date, according to my hearsay sources. By the way, go to Legal Beagle, okay? He's more up to date. But again, I'm kind of going through this of my YouTube just to stretch out with all the other videos the damages that the courts are doing upon we the people. Okay? And only we the people can challenge such jurisdiction because most of our members, I'm not saying all of them, but most of them, is never going to challenge jurisdiction. If he did accept that this attorney right there, then all he would do, win or lose, is going to be kissing her buttocks. But who's the one that has to prove that they have subject matter jurisdiction, right? We just watched a couple of videos of it. She has to prove it. But what is he asking? Asking her instead of asking her. Is there subject matter or personal jurisdiction in the matter? All right, let's go.
If you're representing yourself, the procedure would be to go through a waiver of right to counsel to make sure that you understood all of the ramifications of representing yourself. So do you know if that happened?
That has happened before.
Okay.
Before Judge Mary Lynch in case number 6566749, we had to go through that because I represented myself at trial in September 2020.
Okay. All right. So, Mr. Benshu, okay. So I just want to make sure too that you understand if we go through a waiver of right to counsel and I allow you to represent yourself, it doesn't necessarily. I mean, so you can't represent yourself.
Don't you like to say, how if I allow you? Well, that's not allowment. That's not a privilege. That's a right. That judge has no say in the matter. Period. We are misled to believe that she has any say about this at all, people. Good or bad. If he decides to do it, he takes the consequences, and she don't have a choice in the matter. Okay? Just listen to the words. And again, we're going to go back with the 48 laws of the previous videos I've done. So check them videos out.
And not represent yourself. This has to be done with the permission of the court. Otherwise, it gets very...
Has to be with the permission of the court. And I understand that there could be some things going on in the background, but it's not a permission thing. It's a right, and you cannot change a right into a privilege. How does she not know that? And does she know it and trying to trick him?
Confusing because the city has to know who they're dealing with, whether they should be talking to you or talking to an attorney because...
And again, we're going to go with my previous deal, right? When did she become the city? Well, the city. When did she speak to the city? When did the city come over with affidavit under penalty of perjury and say, hey, this man caused me harm?
could find themselves in a difficult ethical position if they think you're representing yourself, but in fact you have someone representing you. So do you understand so everyone needs to be on the same page.
Well, I would actually find it refreshing if the city started comporting themselves as if they were concerned about their ethical behavior.
I had to pause it right there just for you guys to read it. Call them out. You got to love it. And see, a lawyer wouldn't do that, but a pro se can.
So far, after nearly 4 years, I've seen no evidence that the city, through its officials, cares about ethical conduct.
Great. Call them out on their misconduct. This court and the city has nasty hands operating in bad faith and making the courts muddy and yucky, and she is agreeing to it. Now, just so you guys know, I am under, I'm led to believe and do believe that this is administrative action at the present time. All right? Because everything is administrative nowadays.
Okay, well, that's not exactly answering my question, but okay, Mr. Roy and Ms. Carsonson, what I am suggesting we do is I would like to go over the waiver of right to counsel with Mr. Benshoof, and then once that's established, we can proceed. So I just want to make sure, Ms. Carsonson, if you had anything you wanted to add before I do that.
The city has nothing to add. Thank you, Your Honor.
Okay. So let's do this. So, Mr. Bench, you're familiar with this form just because I know that you went through it previously on a different case. So let me go through this with you. Okay. So right now you are charged with 2 counts of stalking, 1 count of custodial interference, and 86 counts of violation of a vulnerable adult protection order. And so I want to make sure that you understand that if you're found guilty on any of these charges, you could be facing a maximum penalty of 364 days in jail on each count and a $5,000 fine on each count. So do you understand that that's the maximum that could be imposed if you're found guilty on any of these?
I understand that if the city had jurisdiction, that could be a possibility, Your Honor.
Okay, so
You got to love how he's wording his words carefully in the matter.
the city, okay, so do you think the city does not have jurisdiction?
I know the city doesn't. We can start all of these DV cases at case number 669329. I appeared on November 16th of 2022 by special appearance before Judge Willie Gregory. I informed Mr. Gregory that the city, through prosecutors Sahila Serafan and Katrina Outman, had failed to provide the city with proof of personal jurisdiction, specifically complying with RCW 35.20.270 subsection 1, which requires the city in issuing either criminal or civil summons to do it through the chief of police, a police officer under the direction of the chief of police, or the county sheriff, or a deputy under the direction of the county sheriff. That didn't happen. In fact, the city has a custom and policy of supposedly obtaining personal jurisdiction via a USPS first class mail letter. That violates RCW 35.20.27. I have Katrina Outland signing her name in red ink in both state and federal court, admitting that it is the custom and policy of the city to violate that aforesaid statute, because that's just how they do things. So that was the personal jurisdiction issue, and this has happened in all of these cases. Unfortunately, in that case, 669329, November 2022, Judge Gregory simply played the typical game, which is, well, if it happened within Seattle city limits, we have territorial jurisdiction, and because I'm wearing a black robe, and because I say we have jurisdiction, we get to ignore personal and subject matter jurisdiction. I hope that anybody who has attended law school and graduated knows that that is a bunch of baloney.
Okay, so Mr. Ben,
Again, pro se's can only do this. And I know you guys probably can't see it unless you're on a big TV, but his eyes right there is like, ooh, boy.
hold on. Okay, so I understand that you are objecting to the city having jurisdiction on these cases. I understand that. So what I'm going to do is note your objection. Your position is the city doesn't have jurisdiction, but we're going to continue. So your objection is noted.
Thing to citing explaining why the city doesn't have subject matter jurisdiction, and that's because the Seattle Municipal Court is a court of limited jurisdiction. It is not a court constituted under Article 4 of the Washington State Constitution. It's created under statute, specifically RCW Group 35. If you read RCW 7.105.050 subsection 1, parts A and B, it states unequivocally that in an allegation that I or someone else has violated a allegedly valid restraining order from family court, which is King County Superior Court, involving a minor child, which my son is still a minor, that only the Superior Court has jurisdiction to adjudicate the alleged violation of that statute. Not even King County.
So, okay, Mr. Benchu, please hold on just a moment. So I understand that your objection to the city not having jurisdiction, and there's a time for that. So if you're going to be representing yourself, which it looks like I probably will, but we need to get through this form, then there'll be an opportunity for you to ask for a motions hearing, to file briefing, and to argue jurisdictional.
Because jurisdiction is a threshold matter, I object to the notion that the city gets to proceed with arraignment and proceed under the presumption that they have jurisdiction, because I've explicitly challenged it on the record, and I've been challenging this since November 16th of 2022, and yet the court has proceeded in violation of 18 United States Code Section 1962, Federal RICO, violation of my rights under 18 U.S.C. Sections 241, 242, and enough is enough.
Okay, so Mr. Benchiff, I'm noting your objection, and again, I'm going to tell you that you have an opportunity to brief this and argue it later, but we first need to establish the...
See, and there lies the problem. There has to be proven jurisdiction before she can move forward. And her Supreme Court bosses told her such. But yet, they're going to go ahead and proceed forward to whatever process that they seem fit. And this is the reason why the other judges are in the process of being sued, is because they keep violating the due process.
You're going to represent yourself. So my next question for you is that is your decision to represent yourself voluntary on your part?
Yes.
Okay. And then, sir, what's the last grade that you finished in school?
I have a high school diploma.
Okay. And then, sir, it appears that you do, but the question is, do you speak English fluently?
Hopefully.
Okay. That sounds like a yes.
Yes.
As I'm able to converse with you today, have you ever studied criminal law?
And I find study.
Okay. Do you want to tell me?
I haven't done any formalized schooling study.
Okay. But it sounds like you've done some informal study though, then?
Yeah.
Okay. Okay, so Mr. Benchu, have you ever represented yourself or any other defendant in a criminal action? So you'd mentioned earlier that there was a case where Judge Lynch was the judge.
Yeah.
Yes.
Settlements Court case number 656-749, September of 2020.
Okay, I'm sorry. It was 656
749.
749. Okay, thank you.
Which was itself a malicious prosecution in violation of the Civil Rights Act of 1964 and seminal civil rights cases such as Amity City of Rock Hill and the state of Georgia v. Bishop.
Okay. Again, that's noted. All right, Mr. Benchu, do you understand that if you're not a United States citizen and you're found guilty of a crime, you could be deported, excluded from admission, or denied naturalization?
I understand that statement.
Okay, thank you. All right, and then do you...
So pause right there again. I understand the statement. So he never agreed to her understanding. He just agreed to what she just basically said, right? The trickery of words that he's using right back on them, as well as the trickery of words they're using against him.
realize that if you're found guilty of more than one crime, the court can order that sentence to be served consecutively, meaning one after another. Do you understand that?
Yes, Your Honor.
Okay.
Sorry, it's hard not to laugh at the thought of 89 consecutive charges relating to me texting with my son and dying in King County Jail. It's so preposterous.
Okay, you don't need to explain. Sir, you don't need to explain. Okay, let me get on to the next question.
We're going to pause there or go to the next part. This will be the People News. Bye, y'all.